Welcome to our coverage of the Noor Salman trial here on ClickOrlando.com. Thanks for being with us. I'm Ginger Gadsden. We are now at the final stage of this trial. The fate of Noor Salman is in the hands of the jury. Just after 9 this morning, they were back in for deliberations. But right now, the jurors have broken for lunch. And we want to remind you, these are the two charges jurors are reviewing: aiding and abetting the provision of material support to a foreign terrorist organization, and obstruction of justice. They must decide if Salman knew about and helped her husband, Omar Mateen, carry out the shooting at Pulse nightclub. So let's get right out to News 6 investigator Mike DeForest. He's outside the federal courthouse in downtown Orlando this afternoon. And Mike, those jurors have been deliberating for quite some time now, and we know they've already asked quite a few questions so far.
Hey, Ginger. Yeah, they've been deliberating a total of about 6 hours, and there have been, I think, about 3 occasions now where they've brought some questions to the judge or asked to see some evidence. This morning, in fact, they asked a question. It seems like they're having a little bit of difficulty or trying to better understand the term aiding and abetting. Let's pull up a full screen we made for you here. According to the jury instructions that they received yesterday, a defendant aids and abets a person if the defendant intentionally joins with the person to commit a crime and commits an act which contributes to and furthers the offense. Now, Noor Salman is charged with aiding and abetting her husband, Omar Mateen, as he provided support to a terrorist organization. Now, the jury instructions also state you must find beyond a reasonable doubt that the defendant was a willful participant and not merely a knowing spectator. Today, the jury asked for a better definition of the word willful, which the judge provided. They also asked for an example of aiding and abetting, which the judge felt would just not be proper to give them right now. We are joined by attorney Mark O'Mara. This concept of aiding and abetting, if this was a homicide charge, I think the average person would know what a homicide is, but a concept like aiding and abetting is probably a bit difficult for most of these folks.
Well, and really what it is, the essence of it is you have to do something with the intent to further the other act. So if I'm aiding and abetting you getting lunch, I might drive you to get lunch. It's an affirmative act that you have to take. And that's going to be the problem with the government's case, is trying to come up with that affirmative act that did more than just be there. Driving in the car with Mateen wasn't enough. Making a plan for him might have been enough. Somehow furthering the act. And that's also why I think they had a question about the concept of willful. The behavior has to be, again, with the intent, the willful intent to further what Mateen was doing.
So if she believed, or if she had a suspicion he was going to commit a terrorist attack, if she drives him to Walmart to buy ammunition, but she did not willfully think that was going to be part of this plot, then...
Well, it's a great example, because if she knew that's what he was planning, and she helped him, that's aiding and abetting. If she didn't know that's what he was planning, but just goes with him to buy ammunition, the fact that he's buying ammunition, unconnected to the intent to aid or to future ISIS, then she's not guilty of anything. And let's also remember this one premise. When a jury asks a question, sometimes it's the entire jury that doesn't know what's going on. Much more often than not, one juror has a question, or maybe 1 or 2 jurors, where they don't know exactly what this one word might mean. So it could be that the entire jury is trying to clear it up for simply one juror.
And just your thoughts as an attorney when the jury is even asking so many questions or asking for evidence. I know there have been cases where you'll have a verdict rendered with no questions from the jury, and I would imagine you go back home and wonder, did they really understand this? Because a lot of times you don't know the jury thought process after that verdict's been reached.
Well, I would tell you, this is what I get from these questions. They're thinking the case through. They're making sure that they're certain. And whatever their verdict is, I would much rather have a verdict after a dozen questions, which gives us the insight that they're thinking about the case, that they're worried about it, and they want to make sure they give us a just verdict, than if I had a 10 or 15 minute verdict with no questions whatsoever. So we congratulate them for what they're doing. They're trying their hardest in there. We just have to wait to see what the result is.
Now, we know the attorneys and the federal prosecutors are all standing by here. I guess in part for waiting for a verdict, but also in case these questions come up. Talk to us about why it's important to have the defense attorneys there when these questions are being read.
Well, any question that comes from the jury has to be vetted first by the judge to make sure that it is something that can be answered. If they were asking a question which the judge knows simply cannot be addressed, they still have to bring in the prosecution team, bring in the defense team, because no matter what, it's all got to be put on record. So it's put on record, then the parties and the judge decide, can we respond to it? Is it an appropriate question? And then two, how are we going to respond to it? Sometimes it will be simply rereading the jury instruction. On occasion, they may decide to add to the jury instruction to answer the question. Sometimes it's simply a question of reading back some evidence. So every question is going to be vetted out, first by the judge, then by the parties, to get back to the jury.
Well, and it was this morning, as we mentioned, the jury asked for an example of aiding and abetting, and the judge would not provide them. I would imagine that's risky territory for the judge to get into a theoretical situation.
You really can't go down that path too far. The jury instructions have been created to precisely set forth the foundation from which a jury can make a lawful verdict. As soon as you add one sentence to that, one phrase, you have now changed what we all spent a lot of time coming up with as good uniform jury instructions, which is precisely why Judge Byron said, I'm not going to give you an example. If there had been examples given in the jury instructions to begin with, you would have had them. But this is why you use your common sense as a jury to apply these facts to that law with these instructions and nothing else.
As we're just kind of taking a breather here and waiting on this verdict, I know you've been following this case since it began about 2 weeks ago. Any big, interesting legal issues that you've noticed here that have kind of fascinated you as an attorney?
Well, a few of them. Obviously, you've had my ongoing frustration with the lack of having the statement videotaped or audio taped. I'm sure the jury is questioning that inside there. It was very interesting how we found out some of what the government knew, but we only found out now. For example, that Pulse was a complete coincidence. That 2 days, that there was no previous intent, seemingly, and no evidence of it to suggest that Pulse was the target. The fact that they knew that 2 days before or after the event, and yet most of the community, including the gay community, was not told that. Nobody knew that. You know, the fact that Disney was in fact a target was interesting, that it was delayed a year and a half or so for us to find out. So, you know, some of the facts that came out and the way they came out were particularly intriguing to me. I'm a bit worried as to how it's going to happen with maybe a compromise verdict. Maybe that they don't find her guilty of the aiding and abetting, but compromise the verdict and find her guilty of the obstruction for the statements that she did or didn't give properly to the FBI. And what that raises, you know, to the fact that Mateen was already dead at that point, so what was really being investigated that Salman got in the way of. But we'll see.
And if my understanding is correct on how this jury is supposed to decide, throughout the trial, the prosecution threw out several different ways that Noor Salman may have aided and abetted her husband, such as driving into Walmart to buy ammunition, coming up with a cover story. Likewise, the government threw out several examples of the lies she reportedly told the FBI, that my husband hasn't been on our home internet, although they could easily prove that he had been, that he had deactivated his Facebook account years ago, and they could easily prove that his Facebook account was still very active. Does the jury, I don't believe the jury has to agree on which one or multiple of these lies or which one or multiple of these ways she aided and abetted. They could each come up with their own different reason why they think she violated the law and find her guilty?
That is correct. The way that they will come up with a lawful verdict is that they all agree that she did in fact aid and abet. Now, they can come up with it for different reasons. We would hope that the jury will come to consensus as to how they thought she aided and abetted. But there's no special verdict form that has to say, this is the way she did it. They need to look at the case and decide she aided and abetted in a willful way, and then they would come up with a conviction.
And not to be flippant and to say that prosecutors just threw everything at the wall to see what would stick, but I think they did want to give the jury this option, that it wasn't just one offense. And again, it went right back to the beginning, that the prosecutor who began his opening statements said that there is not one single piece of evidence that's going to convince you of this. It is the cumulative effect.
Well, and that's sort of the way you do a circumstantial evidence case. You're building with much smaller blocks, but you're hoping that those blocks still make the wall that you're trying to build. What's interesting from the defense perspective on that is There is absolutely no piece of evidence that is damning, is there? There is no one text from her to him. There is no one statement. There is no one action by her where they can say, look at what she did here, therefore you can use that as the context for interpreting everything else. Rather, they're trying to use very small blocks in and of themselves to say, please see our whole wall.
Well, Mark O'Mara, we really appreciate your insight into this. It has just been a fascinating case, and I think all of us wish we were flies on the wall in this jury room. I would imagine as an attorney, that is, do you ever get much insight to how a jury came back with a verdict?
In Florida, you're not allowed to approach the jurors, so they have to come to you. And if they come to you after the case, you're allowed to interact with them and to talk to them. But no, we never get the insight we want. And what I would ever give to have a videotape on each and every jury when they were deliberating my case, because not only do you get insight on what happens in there, but also on what you did right, what you did wrong, what the other side did right and wrong. So it's an insight that unfortunately we as criminal defense attorneys hardly ever get.
And so it becomes a guessing game, I bet, in a way, of just trying to figure out exactly what you want to present and hope that it sticks with them.
Absolutely right.
Attorney Mark O'Mara, thank you for your insight on this. We are going to send it back to you, Ginger.
Yeah, Mike, I just have a quick question for you. You know, you've been out there since the beginning. Have you noticed more people out today? Because, you know, a verdict could come back after lunch today. Have you noticed any more people out there than you've seen for the past couple of weeks?
In terms of outside the courtroom or outside the courthouse, there is definitely more of a media presence out here, a couple more of the national networks, some print journalists out here than we saw during the course of the trial, just because we know that that verdict is coming. I can say that yesterday during closing arguments, we saw probably the largest presence of spectators in the courtroom. A lot of survivors and victims' family members from Pulse were there. A lot of attorneys and young attorneys show up to kind of watch this case. We know that there were some FBI agents who testified. They were there. So the closing arguments yesterday brought a big crowd. And yes, there's a large group here. There's a very small presence of people in the courthouse. The courtroom doors have been shut and locked. And only when the jury has a question are they opened up, and the parties are allowed to come inside to see what the jury's asking about. And we are supposedly going to be getting about a 30 minutes heads up when a verdict is announced or reached.
All right, and many expect that might happen today. Mike DeForest, thank you very much. And as soon as the jury reaches a verdict, we will bring it to you live on News 6 and online. Meantime, you can get complete coverage of the trial, including more on the rules the jury's using to help them reach their decision here on clickorlando.com/Noor Salman trial. And you can also join us tonight for another discussion. Our coverage begins at 6:30 online. Thanks for joining us, everyone. I'm Ginger Gadsden.